In our opinion, this is the case where the entire selection process is vitiated and tainted beyond resolution. Manipulations and frauds on a large scale, coupled with attempts to cover up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selection are denuded, and accordingly, then we have proceeded to make some modifications in directions given by the High Court. Now, final directions are: we find no valid ground or reason to interfere with the direction of the High Court that services of tainted candidates where appointment must be terminated and they will be required to refund any salaries or payments received. Since their appointments are a result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. For candidates not specifically found to be tainted, the entire selection process has been directly declared null and void. The candidates already employed need not be asked to refund or restitute any payments made to them, or the services will be terminated. Furthermore, no candidate will be appointed once the entire examination process and results have been declared void. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or autonomous bodies, etc. In such cases, although the appointments are cancelled, these candidates will have the right to apply to the previous department autonomous bodies to continue service with those entities. Such applications must be processed by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their positions. Further, the period between termination of the previous appointment and rejoining will not be considered as a break in service. The seniority and other entitlements will be preserved, and they will be eligible for increments. However, for the period they were employed under the disputed appointment, no wages will be paid by the state government or autonomous process. This process must be completed expeditiously and, if required and necessary, this process must be completed within 3 months, and if required and necessary, by creating supernumerary posts for contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and receive wages until fresh election process and appointments are completed. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process, if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will be also eligible to participate. Allow these candidates to take part in fresh selection process, which would now be initiated to fill the vacancies. Our observations and findings would not influence the criminal proceedings. Accordingly, we uphold the impugned judgment, cancelling and block the entire selection process, but have made certain modifications in the directions issued by the High Court. Appeals are disposed of in the above terms. We, however, will independently take up the issue with regard to the appeals filed by the state of West Bengal with regard to the direction of investigation by CBI on the decision taken to create supernumerary posts. Especially petitions to this extent will be listed for hearing on 4th of April 2025 as to costs.
Grateful.